policy making through her engagement with expert groups and committees, such as the United Nations Working Group on Consumer Protection and E-Commerce, and the Committee for the Development of an International Code for the Protection of Tourists at the World Tourism Organization. An elected board member of the International Association of Consumer Law and one of the editors of the Journal of European Consumer and Market Law, Christine has published extensively in her areas of research expertise. Her most recent books include Consumer Theories of Harm, published with Hart in 2019, and a co-edited collection of essays on vulnerable consumers and the law, published last October with Routledge. I understand that her presentation today will be drawing from this book. Please use the Q&A box for any questions that you may have. Christine, the floor is yours.
Great, thank you so much. Well, I'm delighted to be giving a seminar, very much regretting that it's not at the University of Essex, which would have given me the opportunity to meet with a lot of colleagues I do know, and I'm very pleased to see a few familiar faces on the screen and many new ones. So my talk indeed today will focus on vulnerable consumers, and I'm going to now attempt to share my slides with you all. I think that's worked. And before I start my talk, I obviously would like to thank Nikhil and Stavroula and the University of Essex for the very kind invitation and the ability to share that work with you. Vulnerable consumers is really a topic that has now really reached the forefront of consumer policy making. I was sat in the last 2 days at the UNCTAD expert group meeting that takes place every year, and this year a lot of the themes and the discussions surrounded vulnerable consumers and their protection. So the topic that I'm presenting on is not just vulnerable consumers, but actually it's looking at their access to justice. And it is the result of work that is not just my own, but a co-edited book with Séverine Santier at the University of Exeter, and the remarkable patience and dedication of our group of authors who have provided us with a number of chapters that have fed into what I'm discussing today. So there are perhaps too many of them to cite them, but I'd like to very much thank them publicly and acknowledge their wonderful contributions. The book originally started with a seminar that we organized at Brunel, looking at how we could use consumer law as a social tool, how we could actually harness consumer law as more of a mechanism to protect consumers, but more specifically those who perhaps were struggling more in the marketplace than others. And from that grew the idea for the book. Now, the concept of vulnerable consumer and their lack of protection is not a new phenomenon. And the book indeed starts by exploring the work of David Kaplowitz, the seminal book, The Poor Pay More from 1966, 67, that charts consumer practices of low-income families in some settlements in New York City. And what's really regrettable, and I will come to that conclusion a bit later, is that since that time, not very much has changed in the way those consumers are actually being treated by market operators, but also by legislators and by the way we conceptualize people and their economic plight. And indeed, the focus is very much normally on a separation between the individual and the economic agent when we look at consumer law, and that is still very much pervasive. So I want to make a few introductory remarks, and in this talk, I will effectively present to you the introduction of the book and its conclusion. And I hope that this will spark your interest to go and read the many wonderful contributions that we do have in the book. In the book, we do explain that the introduction obviously introduces, and that's very much presenting what the authors have provided us with. But the conclusion is very much mine and Séverine's essay. And whilst it aligns a lot with some of the author's views, it doesn't necessarily match them perfectly. So please do treat a lot of the comments that I make today as being very much informed by our contributors and the wider literature, but very much mine and Séverine's view of the world. So consumer law, and for those of you who are not familiar with the subject, perhaps I need to explain that whilst it is a discipline that seemed to have made much progress and has effectively created a lot of rights and a lot of benefits to many consumers, has also failed to address some key fundamental issues. The bulk of EU consumer law was not created in order to service consumers. Indeed, the bulk of consumer law's view and goal is really to complete the internal market in the EU. And that's an important point to bear in mind when we try and look at ways to protect vulnerable consumers. And what we find is that when we look at access to justice and redress, that's also been something that was placed in the service of the completion of the internal market. So whilst it's a right that is recognized, access to justice for consumers, it is again not to necessarily enable those consumers to get the redress they deserve, but to make sure that the system functions and thus realize this internal market. The consumer law effectively, and that's what Hans Miklet writes about, and Hans Miklet is perhaps one of the important authors if you are discovering consumer law to go and read. It describes consumer law as being instrumentalized. So it's not a discipline that in itself has its own internal goals, but it's a discipline that helps other goals. And indeed, there's another tension with competition law and consumer law, and normally competition law tends to be seen as the main way and the superior vehicle to achieving competitive markets. Consumer law is just an instrument. However, if we look back at the sources of consumer law, what we find is that consumer law originally had a very important social goal. So the main start of consumer law development is also to be found in consumer safety, and therefore there was a slight difference of emphasis. So what we find, fast forwarding this little historical background, is that there is a need for action in consumer law to try and acknowledge and take more seriously the plight of vulnerable consumers and their access to justice. But there is a real disconnect between what consumer law does and what access to justice does. So access to justice, we normally understand it as this concept, which is accessing the tools that will enable a consumer to get redress. So it's the courts or it's ADR. And what we've seen in England or in the UK more widely is actually a withdrawal of the state from dispute resolution, a contraction of legal aid, and a real abandonment of the ways to provide consumers with justice to a privatized system, a system of ADR, alternative dispute resolution, ODR for the European dimension. And this system is very problematic because it's very disjointed. It was never created, as was the courts, to be honest, and thought of as a complete system. it's just been through a piecemeal approach. And we end up with a system that is definitely not very well resourced either. The book didn't aim to try and solve the problem of vulnerable consumers and access to justice, but it wanted to take stock and reflect on the reasons for a lack of protection of vulnerable consumers, to try and understand the main issues and try and craft some tentative solutions. So very much this book is really inviting further research, and I would like to obviously call out to anyone listening who might be interested in the subject to obviously conduct their own research, but also get in touch so we can look at further means. I am currently with Séverine Santier and some colleagues that I see here today, trying to look at ways to get funding to actually develop this program of work. So the book tries to unpick the needs of vulnerable consumers and their needs with regards to accessing justice. And we do that in three main ways in the book. We look at vulnerability from a normative standpoint. So we look at definitions, we look at conceptualization of vulnerable consumers, we look at the way legislation and policymaking might account for them. And we do that at home in the UK, in the EU, and further afield. We've got chapters that chart notably South Africa. We then look at vulnerability from a regulatory viewpoint, and we finally have the third part of the book that is truly devoted to the access to justice element. So what's vulnerability? Well, I suppose one of the main conclusions of the book is it's pretty much impossible to define it, so I'm not going to attempt to give you a definition. But the book and our authors seem to all revolve around the concept and the vulnerability theory that was developed by Professor Feynman. And that has very much become our main framework for understanding inequality. The idea that Feynman's developed is that vulnerability is a constant universal notion, and there's a lot of literature out there that does inform those points, that vulnerability for consumers in particular is something that can come at any moment. And I think the COVID-19 crisis has shown that we could overnight be very vulnerable consumers when we could not access goods of first necessity, pasta shortages on the shelves and loo roll shortages, or when we actually might be struggling with accessing those goods online because we've never been online before. It's not our main way of shopping. There might be some vulnerabilities that are developed there. Vulnerability is something that will also manifest itself not always to the knowledge of the person who's actually vulnerable. So it's really a difficult concept to work with, and yet we see that the legislator in the EU, in particular in the utilities, has started to use it, and we find traces of it in the Unfair Commercial Practices Directive, and no one or nowhere has really defined it, at least not adequately. So no definition in the book is proposed. You won't find it, don't look for it. But what we'll try and show is different dimensions and different potential responses. The first part of the book looks at this normative view of vulnerability, and it very much leads into the exploration of how and if vulnerability is also a good concept, if we should keep it or try and explore something different. There is indeed a lack of coherence in the way the norms are put together. And there is, in my view, also, because of this lack of coherence or this lack of ability to define them, there is not only a gap that has created itself, so we can't protect them because we can't define them in law, we can't protect them. That's pretty much what seems to transpire in many areas. And also there is a real risk of stigmatization, and that's certainly something that I felt very strongly about, that we are creating this kind of two-speed system by making a distinction between those average consumers and those vulnerable consumers that we're trying to protect in different circles. So when we took stock, we asked our authors to very much reflect on those ideas and express that obviously in their own way, and looking at how also a lack of access to justice would feed into vulnerabilities. So this first part then leads to the second one, and what we find, what was quite interesting, is that we ask authors to reflect on whether or not access to justice, access to the tools of justice, so a court or an ADR method, was really the way to think of vulnerability. Was it enough to devise tools to access justice, claim your right after you suffered a detriment? And the responses that we got were quite different from what we were expecting, in the sense that there is a lot of chapters that focus on instead what regulation needs to do, as opposed to what access to courts needs to be given to the consumer. So from that, actually, a lot of the chapters do inform the notion that we need to have a wider understanding of the concept of access to justice, to include not only access to those tools to get a redress, but also to product and services that would be tailored to the vulnerable. And the last part, and the sort of taking stock that our authors are doing, is that a lack of protection, and that's the sort of questions we addressed to them, a lack of protection, was it due, and is it due to consumers actually not engaging with those tools to get redress? I think in consumer law, there's been a myth for many years, and that's what Kaplowitz was also explaining, that we tend to see consumer apathy, not gaining redress, not going to claim their rights, as the fault of the consumer. Well, you know, they could have claimed their money back, they're just not doing it, they can't be bothered. So hey, who cares? We're giving them the rights, they should actually go and exercise them. And what we find is actually a lot of the apathy, the disengagement from consumer, has nothing to do, or very little to do, with not wanting to claim a right, but a lot to do with the fact that we have systems that are very poorly designed and very difficult to access and understand. And that in itself creates a little bit of a systemic vulnerability. So it's the lack of systems that are actually responding to human needs, and I want to stress it's not necessarily about vulnerable consumers' needs, but human needs, that actually creates a lot of what we see. So how do we solve it? And having read all of the chapters and reflected on them, and read wider scholarship, we thought with Séverine that there was ways perhaps to push past systemic vulnerability. And for us, inclusivity really has to be the key word. So we thought that the way consumer law and access to justice itself have been defined and devised don't really look at inclusivity. They tend to try and respond to a perceived need at a time X, but they're not trying to create environment systems that can work and can be agile and adapt to needs. So we opted for inclusivity as a bit of a keyword, which we kept very close to us. And I think it sums up very nicely what we think should happen. I want to stress there also that there's another book coming out on vulnerability, for which I've written the foreword, which will be from a team at Just Energy, who actually have only focused about the energy market and access to justice for access to redress for vulnerable consumers. But bizarrely, we had many discussions with them, and they also wanted to use the word inclusivity, but opted for another one so that they could have a different, obviously, way of defining their work. But I thought it was very interesting that two teams of people ended up more or less in the same place. And I'll share the details if you want of that other book as well. So to be inclusive and enable our vulnerable consumers to have access to justice, what we find is that we need to break through a number of barriers. And there were essentially 4 or 5 that are very strong barriers and problematic issues to reflect on. First are market-driven policies. We have policies in consumer law and in access to justice that are very much driven by markets, by economic efficiencies, and not by not focused on the needs of individuals. And that has created also, because everyone has got a small remit and they're dealing with it and no one is looking at it quite inclusively and holistically, we've ended up with a lot of enforcement silos. So if you have a consumer issue that might involve also some data of yours on the internet, you now have the big, oh, who is enforcing? Is it going to be the CMA? Is it going to be the consumer law enforcement side? And within that institution, there will be, or should it be a competition problem or should it be a consumer problem? And in the past, it's always been dealt with vertically, or should it be a data protection enforcement authority problem? So we find ourselves in those kind of big enforcement silos. We also find ourselves in the justice side in those silos, because it's either the courts or it's the ADR. And we don't really have anything that goes, okay, well, what will be the easiest way and the most successful way of providing redress to that particular individual or to a group of those vulnerable individuals? So that's also a big issue to break through. There's still this issue of how do we conceptualize them? How do we define it? Because if you can't define something in law, you normally can't protect it, because the definition normally tells you what the scope of protection is going to be. So we also have within that conceptualization on the access to justice side, not just the vulnerable consumer, but we also have to look at what is access to justice, what is justice, and what kind of justice do we want those consumers to access. There was also questions, and there's some issues surrounding what is the best way to resolve disputes and offer redress to consumers. And last but not least, and I think the most important one in my view, and for those of you who know me, you know that I make those points quite vocally, I think it's a political choice. Ignoring inequality, ignoring poverty, ignoring the plight of vulnerable consumers is a political choice before it is an economic one. And therefore, that probably will remain the biggest challenge, because consumer law in particular has really been built on political choices that have aligned with neoliberal economics and a strong view of the market, which doesn't necessarily reconcile very well with protecting the weaker in society. So the key building block of this inclusive access to justice come to breaking those boundaries, It also comes, and that's not done very well in the literature and by legislators or enforcers, it's also acknowledging the systemic failures. What hasn't worked in the system that needs to be repaired, fixed, or changed altogether. And our third building block is to look at solutions that will, in my view, require more state intervention than they have in the past. So for the first one, breaking the boundaries and the silos, it's very much what struck us with Séverine Santier is that there is really a huge artificial separation between consumers and citizens. In the way the legislation operates, we are a consumer, we are an economic agent, and that's it. But we are also humans and we're also citizens. And we tend to ignore the needs of citizens. We tend to focus in consumer law only on the needs of the economic agent. But the need of the economic agent is very different depending on who they are. So I often use the example of a washing machine, which if you are a lecturer at a prestigious university such as the one that we are currently at, or the virtually Essex, you probably will have a fairly decent salary, hopefully not as good as they used to be. Oops, sorry, I said it. But you will have a washing machine that breaks. The likelihood is you will be able to replace the washing machine and then move on with your life. And then you might claim for the money or you might not. But imagine now that you are not a lecturer at the University of Essex, but instead you are a single mother of 3 children that lives on a council estate, works very hard all day. When the washing machine breaks, you cannot replace it. You have to live without it. You have to send your children to school without a clean uniform because you certainly haven't got time after a 12-hour day at work or looking after your children to actually also wash their clothes. And that creates some stigmatization of your children in their environment and so on and so forth. So the outcome of a consumer right not claimed is felt very differently by different individuals. And so far, consumer law has never really recognized the impact. We focus on, okay, the good is broken, you have a right to a refund, let's say, and the refund will be the same. It completely disregards everything that goes around it. So that's an issue that, in our view, is problematic because by failing to acknowledge this wider dimension of consumers, that's where we fail to acknowledge vulnerable consumers and their real needs and how we are actually responding to them. There's also, it seems, too much focus on trying to define the vulnerable or to protect that group in utilities, for example, that to us will lead to a 2-speed consumer protection system. So there's the normal system for the average consumer. And if you're not as capable of that as that person because you are not as rich or you are not as clever or you are not as well educated, then you are stigmatized for not being able to go and claim your rights. And there's also an effort in the utilities, notably, to try and define who those consumers are. And whilst there's an awful lot of good work going on and there is results that are notable and noteworthy, there is that risk that we are creating by the back door this kind of 2-speed consumer protection. The quote that we like to use is one from Norbert Reich, who says that the concept of vulnerable consumers seems to encompass still rather superficially those who cannot or can no longer cope with the requirement of modern consumer society. And I think that's definitely something that has stayed with me, reflecting on how we protect the vulnerable. The diversity of responses is also problematic. We're talking about individuals that clearly are not as well versed with their rights and claiming them as they could be. And yet we have different industry sectors defining them slightly differently and proposing solutions to them that also are different. The financial sector has got one way of addressing those issues. The utilities sector has got another way. So as the vulnerable consumer, effectively, whilst I might find some protection in some sectors, I will have different protection. So how do I then follow? I already could not follow what my normal consumer rights were. What are the chances of me being able to cope with that? The perhaps more important aspect and to be wary of is that as redress is delivered in ADR in particular, because that's what the utility sector, for example, is looking at to resolve those problems of vulnerable consumers, we are resolving consumer disputes away from state scrutiny and without any transparency, and also without applying the law. ADR doesn't have to apply legislation. So we have carved some really nice consumer rights for consumers, but we are now sending them to a system where they don't have to be applied. And I think, to me, that's probably where it's the warning signs are the most acute, because there is no real scrutiny of the fairness of decision, whether actually substantively the decisions will be better for consumers. And there's a very interesting chapter from Peter Roth in the book that really reflects on, is a little bit of justice better than no justice at all, or what is it? And I think that's really an important consideration when we are looking at this aspect. So we said, when we ended up concluding that we should probably forget vulnerability as a concept to define, because it was just too complicated, too slippery. And we see a lot of chapters that talk about if you're over-inclusive, you're clashing with neoliberal conceptions. So you basically are unlikely to want to see legislators going too far. So they might not go far enough. So then you don't get the protection that you really need. So we instead thought we needed to perhaps look at how to make vulnerability the core value of consumer protection policies and no longer an afterthought. And that's where obviously Feynman theory becomes very useful. And what we find when we looked at the history is that actually this is what consumer law was first conceptualized to be, a fairly paternalistic conception of consumer protection existed right at the outset, but then I think was quite polluted by the idea of achieving the internal market, which is an economic concern. And I would say it's perhaps denatured the goals of consumer law, and perhaps it's time to go back to that. The second big aspect is to acknowledge the systemic failures. And what failed the vulnerable consumers effectively is this focus on the realization of the internal markets, rather than looking at what the real needs of weaker parties are. And also, and that comes, I think, quite strongly in the book, a narrow understanding what access to justice is. When we talk about access to justice, we are always thinking instantly the mechanisms by which we get justice, as opposed to what is the system we can carve out around it that will be just in the first place. So the chapters that are perhaps highlighting this quite clearly is the one from Sarah Brown, that looks at financial services, so perhaps not going across the boards, but I think there is really an undercurrent of looking at how regulation can service and protect and make sure that regulation doesn't exclude some consumers as well, as a good way to offer some access to justice. The other element that perhaps has failed vulnerable consumers is this myth of the apathetic consumer. And in other work that I've conducted, with Paolo Siciliani and Harriet Gamper, the Consumer Theories of Harm book that Stavroula was so kind to mention, that's what we talk about. We don't see consumers as apathetic. We see consumers to being disengaged for a very, very rational reason. It makes no sense to engage because every single provider is bent on taking advantage and there's no one policing them. So why would I switch bank account? Why would I spend hours trying to change energy provider when in fact, either my saving will be negligible if I'm a very highly paid and highly skilled worker, or actually I haven't got time to do that, and staying at least has got the reassurance that the service is there and it will happen, and I will then not spend hours on the phone trying to get the phone lines back up. So there are very rational reasons for consumers to behave the way they do, rather than being branded apathetic and the fault being pushed at their door for not enforcing their rights. And I think perhaps the most important recognition is that because the justice system is so poor, at least in the UK, and completely stuck in neutral, whereas we've seen advances and discussion on vulnerable consumers on the consumer side, there's very little going on the access to justice, to the mechanisms of justice in the UK. There's court reforms going on, yes, but the ADR system is pretty much in shambles, although there are some bright lights amongst that field. So I don't want to obviously completely dismantle that. But we also have in the UK, and that's one of the chapters by Cosmo Graham makes that point very clearly as well, we have actually very little information about who accesses the courts, how they do it, why they do it. The most reliable study that we have is one that actually shows that whether it's court or ADR is primarily white male, middle-aged and middle class and of higher education standing. So the vulnerable consumers that actually do need it do not use it. They do not have access to redress that will service their needs. So there is a real disconnect effectively between the discourse in consumer law, where we are trying to, and I don't think the what has happened so far has been terribly helpful, but at least I want to acknowledge that there's been efforts and a lot of activity in trying to get something moving. On the access to justice side, there is very little that is being done. And obviously, when we're trying to put the two together, we clearly see a complete disconnect and some courts that are completely underfunded, and the wave of court closures in the UK has continued, and there's been more and more push for government to withdraw completely from this area. And that would not be so bad if ADR was fit and was looking good and offering some good solutions. What we also see is an ODR-ADR system that is showing cracks and many gaps. And in the UK, the Parliamentary Committee report also branded it as broken. So there are obviously limited solutions. So what do we do with all this? Well, there's a lot to be done, but it's quite a hard task. The conclusion of it all for us was Back to the Future. So I'm sorry, it probably shows my age, my cinematographic references, but I thought that was a good analogy to improve dispute resolution and access to justice for vulnerable consumer. We just think that there needs to be a fairly drastic overhaul of our systems, looking at inclusivity to be at its core. But we decided with Severine to take also a pragmatic approach, that we could have devised this amazing system, thought it through, created it from the outset, but the chances of that being adopted or that actually landing somewhere probably were very little. So we tried to also look at what was already there and what we could harness to actually create a better environment. So our first idea was to use the one-stop shop to close the access to justice gap. We also look towards digital justice where appropriate, but there are big caveats with this. And we looked at improved courts as main providers. And that's really, for me, the important part. I think so far what has happened is dereliction of duty on the part of successive governments. Yes, justice costs a lot, but justice is essential to the rule of law, and not having strong institutions, even for consumers, is a real problem. So we thought that well-administered, well-resourced, well-funded court system could have done the job just as well as an ADR system. But we won't know because obviously the funding was diverted to private providers. So we think that we should keep the courts for vulnerable consumers in particular, because we would then avoid the privatization of litigation, which in the States is well documented to have worked to the detriment of all consumers. It also ensures interpretation of statutes continues and can be monitored. And we have a huge problem and huge deficit in consumer law as well. None of the county court decisions are actually publicly available. So we do not know what happens in small claims courts. So that's a huge problem in finding out how those rights that are decided in Parliament and voted into laws actually do translate. And I think that's probably, as we are starting to look into this, and any volunteers to help me out with that would be fabulous, we will find huge problems there possibly, because the view is to try and avoid some modification by the back door of substantive consumer rights. ADR, if we want to be inclusive, and that's our leitmotif, can actually be used, and it can still be used by the courts. So the technique itself is very good, and the chapter by Cosmo Graham actually does put a lot of money on ADR, and we agree only to a point with that. But we can rely on the good techniques, but offer the venue within the court system so that our vulnerable consumers can have one place where they can access justice, and then we can ventilate them to the right and the appropriate method to get their claims heard. And that's really the idea of the one-stop shop, is to try to make sure that the consumers have got one place, and that we also go and meet them in the community as opposed to expect them to come and meet the courts or the ADR providers. At European level, the ODR platform was playing that role actually pretty effectively, and that's what the chapter from Elisabetta Cialis develops. But there's a real need for a joined up architecture, and whilst a single one-stop shop can actually hide a lot of the crack and wallpaper over it, it still does require some coordination and the rethink, an inclusive rethink of what's happening beyond the wallpaper. So I think what's missing also is seeing access to justice through the eyes of vulnerable consumers. I have been in rooms where legislators and policymakers are discussing the plight of vulnerable consumers, and they are all very well off and very well educated and have no concept or idea of what's happening in a council estate or with a family who might be well off, but who someone suffers a disability, for example. So there's a need to really start looking at how we solve the problem of vulnerable consumers by involving vulnerable consumers in those conversations. Digital justice could offer some solutions. We have a few chapters in the book that discuss what they could look like, and some elements of them. It's true that we see more and more activity towards this, and in the UK, notably with the online courts reform. But I think there needs to be an approach where we move slowly in that arena and ensure that we test effectively as we go on, because of course one systemic disability is also digital vulnerability. Sorry, I said disability, I meant vulnerability. And that could also create more problems than it actually solved. So I leave you with those final thoughts. It's back to the future. let's use inclusivity as a main thread to try and solve the problem of vulnerable consumers and their access to justice. Let's acknowledge that it requires investment, but it is a worthwhile investment in a society where our weakest and our most needy members can actually feel included, heard, and as protected as their better off counterparts. That needs a political commitment, but the link to social justice, I think, is essential in order to devise those systems that are going to be fit for vulnerable consumers. And we already have the answers. It's just that I think we've decided to ignore them. If you return to the origins of consumer law, you will find that it was a social concerns that sparked the creation of consumer law. If you go back to the starts of access to justice and the courts, it's very much to be treated as a public good, something that has now been more or less forgotten, but that Hazel Genn argues very vehemently and is very articulate on. It is effectively in consumer markets about fairness by design. It's about looking at how we expect more of our systems and of our traders rather than expecting more of our consumers and the individuals. So inclusivity is about devising a system of consumer redress that, while not excluding one or the other type of system, the courts or the ADR system, will build on the merits of both and will look at the best available solutions. Possibly even better, what one might be the way forward is to use a form of court, state-sponsored or state-sponsored form of justice as a getaway to all justice needs for consumers. And that could hold the key to ensuring access to justice to the vulnerable, but actually more generally for all consumers. Because I want to leave you with that thought: you are also a vulnerable consumer, even if you do not think yourself to be one. Thank you for your attention, and I'll invite now questions.
Thank you very much, Christine, for a very engaging presentation.